Hello students, welcome to Legacy IAS Academy. Today we are going to discuss about a topic that is going on in news for past few days. That is the decision of government to raise the legal age of marriage by doing an amendment in the Prohibition of Child Marriage Act that was passed in year 2006. So we are going to discuss in this particular video that what is the rationale of the government behind such amendment and why there are such oppositions against this act of government and what can be more that should be done to ensure that child marriage does not occur in India. So let's try and in more depth. So first of all, as we discuss, the context in which we are discussing today's topic is because the government has passed or actually proposed a bill, has presented a bill in the Parliament of India, which mainly aims to increase the age of marriage of the women, and also it aims to ensure the harmony in the age limit of marriage across all the religions, cutting across the religious line, and was introduced in Lok Sabha this week. And as of now, this bill has been referred to the Parliamentary Standing Committee for more deliberations and discussions on the bill. If we try to understand the status of child marriage in India, how it has changed or what is the present status. So as you know, prohibition on the child marriage, these acts and bills has been passed since the early 19th century, early 20th century, when the British government was still in power. And the first such survey, when it was conducted, was found that in year 2005, still after passage of or still such laws being in place, around 50% of India's girls were marrying before the age of 18. This data, when again under the National Family Health Survey, the survey was conducted NFHS third. In NHFS third survey, it was found out that this ratio or this percentage has decreased from 50% in year 2005 to around 27% in year 2015 and 16. So that was a significant decline that can be largely attributed to the success of the Prohibition of Child Marriage Act that was passed in year 2006. Then further, the NFHS survey, that is National Family Health Survey, fourth round, when it was conducted in year 2019 and 20, it was found out that the decline again happened, but not to such a greater degree, but a very abysmally or poor extent of almost 4%. And as of now, the total number of or total percentage of girls in India that is marrying, who are marrying below the 18 year of age, is somewhere around 23%. However, we have to keep in mind that the same survey has indicated that even as of now, around 60% of India's women or India's girl are marrying below 21 years of age. So that is a very significant data. That means we can say that almost 23% of girls are marrying below 18 years, while 60% of girls are marrying between 18 to 21 years, and remaining about, we can say 11 to 12% or 10% of girls are marrying above 21 years of age. Now, keeping these statistics, the government wanted to achieve certain objective by providing or amendment in this particular bill. That is, first of all, government is focusing or trying to ensure the empowerment of women by raising the age of or marrying age of the women. Second, it also emphasizes on promoting gender inequality via this amendment in the bills. Third objective in this bill is to increase the female labor force participation that can be accessible. If suppose if a girl is marrying below 18 years or below 21 years, then obviously she will get engaged in the family life, and maybe as per the patriarchal society of India, the family might not support her working out in any of the field. However, if the age of marriage is raised out, the girls will tend to have more education, and then they can participate more in the workforce and employment of the country. Fourth, the bill also aims to enable girls to make them self-independent, and do not depend on the parents or the husband or in-laws, and that is why they will be enabled to make decisions regarding their career, regarding their family life, regarding their children's also in a better way by themselves. So these are the four major objectives the government emphasizes or is trying to achieve via promulgating an amendment in the said bill. However, if we try to understand that what has been the proposed amendment in the particular bill, that is Prohibition of Child Marriage year 2006. So three major amendments are there. The first main amendment is that the bill aims to change the definition of child as given in section 2A of the bill. In the section 2A of the bill, as of now, anyone, whether it is a male or female, if a girl is of less than 18 years of age, then she is considered as a child. while for a guy it is 21 years of age. So the bill tries to make this uniform and make 21 years as an age for defining anyone, like whether it is male or female. If she or he is below or less than 21 years of age, she or he will be classified now as a child. Second, the bill also aims to increase the window for a child to file a petition to declare a child marriage void. Now, this is something we have to understand, that as per the provisions of the Prohibition of Child Marriage Act 2006, that it does not actually criminalizes the child marriage, but also it gives the opportunity for a minor child that she can file a petition in the court and ask the marriage to be void. That means if a girl who is married in 16 years of age, she can go after 1 or 2 years of marriage, or whenever she likes, she can go to the court and ask the court to nullify its marriage, and then court will declare the whole marriage as void. It is different than divorce, because in divorce it is believed or it is in the record that the marriage was existing and then the divorce has occurred. However, the void means the court will nullify the whole marriage and it will be like that this marriage has never happened as per the records of the country or as per the records of the marriage is concerned. So it actually, in the amended bill, actually increases the window for child to file a petition. Earlier, a girl after she marries in 18 years can go till she attains the age of 20 years. That means the window earlier was of 2 years. Now this window has been increased to 5 years. That means earlier a guy can go and nullify marriage up to 23 years, and a girl can go and nullify marriage up to 20 years of age. However, with this amended bill, both of them can go and appeal against the marriage until 23 years of age. So that it has increased the window for petition up to 5 years. Third is, it has introduced a notwithstanding clause, and that is where the major contention lies. Notwithstanding clause says that the provisions of this amended bill will be applicable to all the religions all the religions cutting across all the religious lines, and it will override the personal laws of different religions. For example, if you look at in Hindu Marriage Act, it is said that a girl will be considered a child if she has not attained 18 years of age. Now, as per this amended bill, she will be considered a child unless and until she has not attained 21 years of age. Similarly, as far as the Muslim community is concerned, for them it is considered that if a girl child has attained 15 years of age and is older than 15 years of age, then she can be considered as a major, not a minor. However, as per this bill, if this bill applies, then even for the Muslim community, a girl who is less than 21 years of age has to be considered as a child. So that is a notwithstanding clause. That means the bill will override all the personal law provisions as far as the marriage and the rules of marriage are concerned. So these are three major amendments. Now, what is the rationale behind the changes? Why government wanted to amend the marriage age of the girl? So first of all, government has said that it will promote gender neutrality. As of now, we know that the legal age of marriage for a boy or for a male is 21 years, while for a female is 18 years. Now this bill aims to make 21 years of age for both male and female. So that is why gender neutrality, and that is why it will aim to provide equal rights to men and women to enter into the matrimonial relationship. Second, it also tries to understand that if a girl is getting married in, we can say lesser time, in a younger age, now of course the incidences of teenage pregnancy will rise. So by promoting the age of marriage, or by increasing the age of marriage to 21 years, the incidences of teenage pregnancy government is also trying to bring down. Third, it also said that government also tries to bring down the maternal mortality and infant mortality rate, which is much higher because the children or the girls are getting married in the younger age. Fourth, the raising of age of marriage will also improve nutritional level, mental well-being, and sex ratio at the birth, as a girl will be more mature both physically and emotionally when she attains 21 years of age as per the government. And last is, it might aid women to continue education and livelihood after an early marriage. So that is very important point, because as of now, we know that India is still a patriarchal society and large number of people still reside in the rural areas where they are governed by the rules of society, and still the education of a girl child is not taken into consideration or not given so much importance in India. And that is why when a girl attains the 18 years of age, the parents as well as the family members wanted to get the girls married and send them to the in-laws house. So now if the legal age of marriage for the girl is raised to 21 years, she will have an extra 3 years, and as the parents cannot marry her off, they will maybe encouraged to let her continue her education, and if she continue her higher education, it is very much possible that she might get a good job and all these things. So better, her life will become more better, she will be more educated, and her livelihood after even marriage can be much more better than earlier. Now, apart from this, however, there are some good points, but still the members of parliament as well as some members of civil societies, NGOs, and the eminent journalists and intellectual class of people are protesting or opposing this bill on the few grounds. First of all, the bill seems to have inculcated the paternalistic, or we can say bill have reinforced the paternalistic approach of the Indian society, because now, as if you consider the patriarchal nature of India's society, till now, if the legal age of marriage for a girl was 18 years, that means after 18 years of age, she is free to marry anyone she wishes, even against her family's wish. However, if the legal age of marriage is raised to 21 years, now a girl has to still remain within the confines of her family, or still have to take approval of her family if she wants to marry between 18 to 21 years of age. And that is where the paternal dispute can happen, or the family dispute can arise, where the parents or the family will not want the girl to marry someone from maybe outside caste or maybe interreligious marriages. So that can actually reinforce the paternalistic approach of Indian society. Second, the bill is criticized on the ground that it actually limits the personal law, as we have discussed that in Muslim community the marriage age or considered as 15 years. Anyone who has, any girls who has attained 15 years of age is considered as a major, and she can marry someone. But it will, if this bill actually overrides this particular convention or particular personal law, then that can cause dispute. Third is, it is also believed that such changes will further push many marriages to the brink of illegality and marginalize vulnerable section. As we discussed initially, that still around 60% of India's girls or India's females are marrying marrying up to 21 years of age. So that is why many such marriages can become illegal. And it is also believed that many people are saying that a lot of romantic relationships are there, a lot of marriages are there that comes out that are a result of romantic relationship which develop somewhere between 18 to 20 years of age. And that is why the people who are in this particular age, even if they want to have a consensual marriage, they cannot do this because the law is not on their side. And that is why we can have cases of honor killings and such that can increase. Fourth contention is regarding, as it is believed that the bill is against the Article 25 of the Indian Constitution, as it violates the right of any society to practice its religions and its religious proceedings and religious following as they want. So it is against the right of freedom of expression of religious beliefs, because as we discussed, in some communities the legal age of marriage as per personal law is less. However, this bill will override such conventions. So this is why it is against Article 25. So these are the main 4 points why bill is being opposed by different sections of the society. Now, as you know that whenever there is such contentions, when there is contention between different members of parliament, or between executive and legislature and different sections of society, we have to understand that the judiciary stance is final. So let us try to understand that what has been the stance of judiciary as far as the overriding provisions in the bill that has been given, that the bill can override the personal laws of any particular community or religion. So first of all, we have one example from year 1996. We have to understand that the judiciary stance has not been very uniform. It has been varying from time to time. So first of all, in year 1996, we have an example where the judiciary has categorically stated that church, in terms of marriage, cannot solemnize a second marriage of a party unless and until the first marriage is dissolved by a court. So that means even if a person or a couple has went to church and have nullified their marriage, have taken a divorce, the church is not authorized to solemnize the second marriage of any of these spouses unless and until the same marriage has been dissolved or divorce has been granted by the legal court or granted by the court. Second example is earlier from year 1960, when the government has said, when the Supreme Court has said that the matter was referred that whether any bill or any act of the government can override the personal laws of any community. So in that, Supreme Court has clearly said that this is possible. And the example you can see from the Transfer of Property Act 1882, that Supreme Court said that will apply over Muslim law as far as the transfer of property is concerned. Similarly, the next stance was taken in year 2009 when the judgment was given in the case of Savannah Bano versus Imran Khan, where the Supreme Court has categorically stated that a widowed Muslim woman is still have right to claim the maintenance from her husband under section 125 of the Criminal Procedure Code even after the expiry of iddat period, that is called as mourning period. As per Muslim personal law, a woman can claim maintenance only after divorce unless the period of iddat is going on. After the period of iddat or period of mourning, the male is not expected to give her the maintenance. However, Supreme Court has said that even after the period of iddat, the Muslim woman has the right to ask for the maintenance, because this is what is said in the section 25 of the Criminal Procedure Code. So here we can say the Supreme Court has said that the general law of the constitution or constitutional law will have superiority over any personal law. If you look at some other instances to understand the stance of judiciary on this particular issue, so one example is from year 2013 in the case of Seema Begum, daughter of Hasim Saab versus State of Karnataka. In this particular case, Karnataka High Court has actually said that no Indian citizen on the ground of his belonging to a particular religion can claim immunity from the application of the Prohibition of Children Marriage Act. That means all the provision of this act will be applicable on every section of the society, whether it is religious society or religious groups, or whether it is a particular community, because they are the Indian citizens, and that is why they have to believe, and all the constitutional laws will be applicable over them and will override the personal law. However, we see a change in the stance of judiciary in year 2021 when the Punjab and Haryana High Court granted protection to a Muslim couple where the girl was a 17-year-old and she was married to a 36-year-old man. So as we can see in Prohibition of Children Marriage Act, she is not allowed to marry unless and until she has attained the age of 18 years, but still she has married in the 17 years old. However, Punjab and Haryana High Court has upheld this marriage, and they said this marriage is legal marriage because it is as per the provisions, or it is in accordance with the personal law of the Muslim community. And that is why the court has said that Prohibition of Children Act does not override personal laws, and that is why in this particular case Muslim law will prevail. So we can see we have two different instances in judiciary. One from the Karnataka High Court, where the court has clearly said that Prohibition of Children Marriage Act will override the Muslim personal law, while Punjab and Haryana High Court has said that it is the Muslim law that will prevail over the Prohibition of Children Marriage Act. One other example is from 2006, where the Supreme Court has said that Prohibition of Children Marriage Act override personal laws, and this was in 2006. It was the Gujarat High Court which has clearly stated that Prohibition of Children Marriage Act override any personal laws of any religion, and taking that into account, the High Court has sent a minor girl to a care facility and said that her marriage is nullified. So that is the whole stance of judiciary. We do not have any uniform stance, and we have to take into account, and we have to see that how, when this amendment is passed, if the matter is referred to Supreme Court or High Court, how they will interpret this amended bill as per the personal law of different communities. Overall, if you look at the stance of Supreme Court on the personal law, so the historical judgment or historical case of Saira Banu versus Union of India, where the issue of triple talaq was there, and triple talaq was nullified, triple talaq was abolished by the Supreme Court because it does not fit into the constitutional law. And it has clearly said at that time that all personal laws will have to fall under the constitutional framework and will be subject to public order, morality, and health. Supreme Court has given three exceptions, and if any personal law of any community does not or alters or tries to disturb the public order, morality, and health, then on these three bases, so constitutional law will have supremacy over the personal law. And that is why it is believed that if the matter with respect to this particular bill, this current bill, the amended bill is referred there, on the ground of health, it can be, government can put its point or put its stand that on the ground of health, this bill or the provision of this bill, where we have the raising the age of marriage to 21 years old, 21 years should be applicable over the Muslim law as well, and should override the personal law of Muslims. That is the overall stand of the Supreme Court on that. However, if you look at that, what more can be done so that the main objective of the government which we try to achieve by raising the age of marriage, what else can be done to attain the same objective? So first of all, we have to understand that the government should focus on reversing the fundamental structural disadvantage that a girl faces in a patriarchal society of India as well as the rural societies of India, where still we can say the dominance of male members and dominance of family members and the wishes and will of family member overrides the wishes or will of any particular girl.